under the code. And there are many case laws or disciplinary order against the RP for not fulfilling their responsibilities towards the avoidance filing application for the avoidance transactions. This is because the clawback the money to the corporate debtor. This increases this maximize the value of the asset of the debtor towards the resolution process, and which is one of the major objectives of the code. That's why it is gaining very much importance nowadays. Another thing I like to say that generally we say there are two stages for the insolvency resolution process. Firstly, we say that stage one is the insolvency resolution process, and then the liquidation or bankruptcy process. And this filing the application under for the avoidance transactions, it comes under either CIRP process or liquidation process. But friend, according to me, this function, this activity is altogether independent and separate process. According to me, it is a separate stage itself. I'll discuss with you in detail with my subsequent slide. But according to me, this filing application for avoidance is a altogether separate, different from your separate CIRP process and liquidation process. So I have prepared one slide for the session, my presentation for the session, and I like to share it with you. Just a minute. Is it visible? Hello?
Yes, yes, it is visible.
Okay. So before we start, there is as usual some disclaimer from my side, like the presentation which I have prepared and I am going to present before you contains my personal view. It is not a legal opinion as well. If situation arises, I suggest all of you take the advice of your lawyer. And the matter which I have interpreted in my presentation can be interpreted differently by others. So let's start. The Insolvency and Bankruptcy Code (IBC) has been enacted as a code in India which seeks to consolidate the existing framework for insolvency resolution by creating a single law in this area. So the main idea of the legislature is to have a consolidated act for the proper addressing the insolvency situation in the country. The Insolvency and Bankruptcy Code was introduced in Lok Sabha in December 2015 and got the consent from the President of India in May 2016, and it became effective in 1st December 2016. It has been made as an one-stop solution for resolving insolvencies, which is a long process and does not offer an economically viable arrangement earlier. I am coming to this, why I am saying so. So if you see this, you are aware, you know that prior to the introduction of IBC, there are different laws, different acts to address the insolvency situation in the country. To take the name like Sikh Industrial Companies Special Provisions Act, SICA 1985, the Presidency Town Insolvency Act 1909, the Provincial Insolvency Act 1920, even our Companies Act 1956 and 2013 also, then SURFACE Act. But you know what's happened, though there are different act, but these acts are totally independent of each other. They are not complementary to each other, and they address the different issues also. Like Sikh Industrial Companies Act, it talks about the manufacturing company which has gone to BIFR. Presidency Town Insolvency Act, it talks about the individual insolvency for the Provincial Insurance Insolvency Act also for the individual insolvency. Even our Companies Act also talk about the winding up provisions for the companies. Not a not all these acts, they do not address the insolvency position as a whole for the economy. So IBC was framed, and you know what is the problem with this? Since they are not interlinked to each other, one can file a case under a particular act for a particular matter. The same person can file the case under the other act for the same matter. And unless and until the decision for both the cases are come out, are received, nothing can be done. So this becomes a time-consuming matter for addressing the insolvency situation. So IBC was framed with the intention to expedite and simplify the process of insolvency and bankruptcy proceedings in India, which definitely will appreciate. It strives to protect the interest of stakeholders to make the process of doing business an efficient task. Not only the doing business, it also make the exist from the business. You know what's happened? Not only, I mean, not always that there is some malignant intention. That's why the company gone into the insolvency or becomes not a viable proposition to conduct the business. It may happen that maybe something has happened for which it is now not viable. So in that case, this act, this code also provide the quick exit of those things, of those companies from the scene without much hassle. It provides a strong insolvency framework where the cost and time. That's why I already said that this is the reason this framework, the cost and time incurred is minimized in attaining the liquidation. If you have any question, you kindly ask me then and there, okay? Because you will appreciate that it will be easy for me to answer your questions with the help of my slides, which I am presenting. So having said so, you can understand the unique proposition of IBC. What makes the IBC different from the earlier scenarios where all these acts are present in the country? First of all, it is a consolidated law. Yes, it can address the insolvency position of any and every each and every circumstances, be it the Sikh industry, be it the individual, be it the company. So, and it also provides for a time-bound process. We will discuss, and also you know that in the code and regulations itself, the maximum time limit is specified. So it provides for a time-bound process. It provides for the maximization of asset value. And because of this proposition, these avoidance transactions are incorporated in the code. Because I said that the clawback of the money which has gone out from the city, if it comes back through this avoidance transaction application, this maximizes the asset value of the corporate. It promotes entrepreneurship, yes, because if the resolution plan is approved, then the new management will come, will take over the company. It will guide the company to a solvency. Credit availability, of course, yes, because through the resolution plan itself, the financial creditors get back their money back, which they have given as a loan to the corporate debtor. And in all, it balancing the interest of all. So these are the unique propositions of IBC, and for which purpose it was framed. Friend, whenever I make a presentation on IBC, any subject on IBC, I generally I go through the objective of the code. This objective is given in the preamble section of the code. And if you go through this objective, you can analyze, you can understand the each and every action taken or order given for any activity of the code. So what is the objective of IBC? It said that it is an act to consolidate and amend the laws relating to reorganization and insolvency resolution of corporate persons, partnership firms, and individuals in a time-bound manner. All the erstwhile acts are consolidated and it addresses all kind of situations, be it the corporate person, partnership firms, and individuals, and in a time-bound manner for maximization of value of assets of such persons to promote entrepreneurship, availability of credit, and balance the interest of all the stakeholders, including alteration in the order of priority of payment of government dues, and to establish an Insolvency and Bankruptcy Board of India, and for matters connected therewith or incidental thereto, be it enacted by Parliament in the 67th year of the Republic of India as well. So what's happened, if you see the earlier act or laws, everywhere it is mentioned, the first recovery, the payment against the recovery first will go first to the government. If there is any tax due, it will first, we have to pay the government. If there is anything, any cess, any tariff related to the government is pending from the corporate debtor, earlier we have to give it to government. But here is the code. It says, firstly, the secured creditors who have financed the business of the company will get back their money. Government priority has come much later. So you can see the basic intention of the legislature is to have a sound economy through their code, through this code. And you can see that I have underlined one sentence, for maximization of value of assets. This is because due to this objective, I told you earlier also, due to this objective, all the provisions of the avoidance transactions are incorporated in the code and its regulations. Okay. Now we see what are the objectives behind determination of avoidance transactions. We have seen the proposition of the IBC. We have seen the objective of IBC. Now we will check what is the objective for determining the avoidance transaction, why it is required. Under IBC, resolution professional is responsible for the task of overseeing the business of the corporate debtor. The RP is entrusted with the duty to protect and preserve the assets and manage the operations of the corporate debtor as a going concern. One of the responsibilities of the RP includes determination of avoidance transactions which were made by the erstwhile management or suspended board of directors of the corporate debtor in bad faith. Friends, I have already told you that one of the propositions is the balancing the interest of all stakeholders is one of the objective of IBC of the code. So, if the main purpose, main objective of incorporating the avoidance transactions within the code is to set right the malpractices done by the management or suspended board in relation to the other creditors, other stakeholders. And mainly these transactions include preferential, undervalued, extortionate credit transactions, and fraudulent and wrongful transactions. You can understand that through all these transactions, the malpractices or the, what should I say? I mean, something can be done by the management which affect the interest of the other stakeholders, other than the management or the board of directors. The object behind the provisions regarding avoidance transaction is that if such transaction is determined, then such transaction can be reversed so that such assets can be utilized by the RP to achieve the purpose of the code, that is the maximization of value. That is for the revival of the corporate, of course, that is for the revival of the corporate data. More you add value to the assets of the corporate data, more person will be interested to submit their resolution plan for the corporate data. It ensures that no creditor should be placed in a beneficial position more than what such creditor would otherwise receive through the distribution as per waterfall mechanism, and also to ensure that defaulters should not go scot-free if the funds of the corporator have been siphoned away. Just now I told you that the government dues has come down in the for the payment from the recovery. You know, there is all of you know that there is a provision, there is a section in the code 53 which talks about how the distribution to be made. It categorically says the priority for the distribution of money which is recovered through this process. And the main intention of this avoidance transactions provisions is to ensure that no one can take the benefit which is not as per that waterfall provision, waterfall mechanism given under section 53. And if any fund is taken away from the business of the corporator, through this filing application for avoidance transaction, we can take back this money to the business of the corporators. The relevant provisions of the avoidance transaction are based on the ancestral legislative guide on insolvency law. It is as per, I mean, we have our code is based on that ancestral legislative guide on insolvency law. But you know, this concept of avoidance transactions are not new under the laws in India. The Presidency Town Insolvency Act 1909 and the Provincial Insolvency Act 1920 deal with such provisions, barring the alienation of asset by the insolvent individual to any person which would negatively affect the interest of bona fide creditors of such insolvent individual. It was there. These two, the such provisions, that avoidance of transaction provision was also incorporated in these two acts. But as I said, that these two acts only deals with the individuals. So this opportunity, or this, what should I say, this thing cannot be done in case of a corporate debtor. This thing cannot be done in case of the bank's borrowing. So to cover up all these defects, all these loopholes, we have a consolidated code by enacting the Insolvency and Bankruptcy Code. The law pertaining to avoidance transaction is given under Part 2, Chapter 3 of the Code, and it applies both insolvency proceedings and liquidation proceedings. In liquidation proceedings also, liquidator, if it has the information, if it has an opinion, it can file the avoidance transactions application to take the money back to the CD, and in that case, we will discuss it later. That will be considered as the part of the liquidation estate. So it is called, why it is called avoidance transaction? It is called avoidance transaction as when a corporate debtor, the corporate debtor becomes potentially sick, the activities of the management of the corporate debtor should be shifted from shareholder centric to creditor centric. Friends, you know that the actual owner of the company is its shareholders. So when the company formed, definitely company activities of the company all are lead towards the benefit of its shareholders. More business, more sale, more profit, more dividend to be given to the shareholders, all these things. But when these things, when the company is not doing well, it is going to be a sick company. It is felt that all these activities of the company should be benefit to the should be shifted from the shareholder centric to creditor centric. This is because creditors are also the person or body corporate who have invested their money in the company. And if you see, they have the huge, maybe more than the shareholders. They have invested their money. So if you say that we have to balance the interest of the stakeholder, at this stage, the company should act for the benefit, or it should be creditor centric. Activities of the company should be creditor centric. That's why all the activities which they have performed earlier for the benefit of the shareholder should be avoided. That's why it is called avoidance transactions. So proper care should be given to protect them by avoiding certain transactions. And what are these are also called PAFE transactions. You know, PAFE is an abbreviated word. It includes preferential, undervalued, fraudulent, and extortionate transactions. And you will appreciate that through all these activities, the interest of the creditors may be hampered. Now, friends, I want to discuss with you a very, very important concept, which is called twilight period. I'm sure you heard about it. So, you know, this term twilight period has not been defined in any particular legislation. No legislation, no act, no law define the word term twilight period. But if you see the dictionary meaning of this term, it indicates the period of time before sunrise or after sunset, during which the atmosphere is neither totally dark nor completely lit. It is hazy. So when that, I mean, during that time, it is called twilight period. You can see, you can see something. You cannot see very clearly what is happening, but you can visualize very, something there, because it is not completely dark. Some light is there, but at the same time, it is not completely lit also. So the atmosphere is very hazy. As such, in common business parlance, it is referred to the period of trading when the company has insufficient funds to pay its debts on the verge of insolvency. So if you compare that scenario in respect to the company business, it really period indicates that period when the company may be solvent earlier, but now it has insufficient fund to pay its debts. And maybe it is in the verge of insolvency, not yet declared insolvent, but maybe it is heading towards the insolvency. So that is the twilight period for the company. The twilight period has serious business implication for any company because it determines whether company will emerge from its distress situation or will be liquidated. The management of the company, they can understand very clearly during the time whether this situation, this twilight period situation is temporary in nature. Is there any possibility to recover from this, or it is a, I mean, it is a real truth. The company will be liquidated. So this can be understood by the management very clearly than the outside. We can see, okay, the company is not doing well, but what is the fate of the company can be understood by the management or the board of directors. Thus, the decision taken by the management, and when they understood, okay, this is the real fact. The company is go to the liquidation. It won't be survived. And you will appreciate that at that time, lots of what they do, which affect the interest of other stakeholders. Mostly the work is done for the benefit, for their individual benefit, not for the benefit of the other stakeholders. So thus the decision taken by the management on behalf of the company significantly impact the outcome of the insolvency process when the company or its creditors formally commences. So when finally when the insolvency resolution process starts for the company, the decision taken by the management or the board of suspend and okay board of directors at that time, it has a significant bearing on the interest of the other stakeholders. Clear? So there is a need to make the management more diligent, prudent, and aware of the decision making during twilight period. And IBC introduced specific duties that are owed by the management towards the creditors of the corporate debtor which is in financial distress. And how IBC introduced these specific duties? Because through the introduction of various provisions towards the avoidance transaction. If you see the code, it mentioned that during this period, just before the CIP period started, you cannot do or you should avoid these transactions which are incorporated in various sections of the code. During this period, the transactions that are entered into by the corporate debtor are vulnerable to scrutiny. And these provisions also made in the by mentioning the look back period and might give rise to several liabilities on the part of the management. Yes, there are the provisions for the penal provisions also there. The period of financial distress where there exists a reasonable cause to believe that insolvency of the corporate debtor may commence. The management have a duty to minimize the losses to the creditors and protect the assets of the corporate debtor. I have already told you these things. So instead of doing this, if they don't protect the assets, if they do something, I mean, by siphoning out the asset value from the corporate debtor, the code has introduced these provisions for the avoidance transactions. The shift of duties of the management from shareholder centric to creditor centric during twilight period. We have already discussed. So friend, we have discussed the very important concept under this avoidance transaction process. So if you have any question, you can ask me. Otherwise, I'll go ahead. Good. So let's see the provisions which are incorporated in the code for the avoidance transactions. I have already told you that avoidance transactions are also called as profit transactions, which is an abbreviated word which stands for preferential, undervalued, fraudulent, and extortionate transactions. So preferential transactions, these are covered under section 43, which says that preferential transactions happen when there is transfer of property or an interest to benefit a creditor or surety or guarantor over other creditors for or on account of an antecedent debt owed by the corporate debtor. Here, two very important points has been mentioned. It said that transfer of property or an interest for the benefit of a creditor, surety of guarantor. So there should be a transfer of property, transfer of fund, transfer of asset, transfer of property of the corporate debtor over other creditors for or on account of antecedent debt for an existing debt. If it is as such transferred without any debt, having any debt, that covers under the separate provisions. Avoidance transactions, but separate provisions. Here, preferential transactions talk about the transfer of property to the creditor or surety or guarantor to give them and benefit for an antecedent debt owed by the company debtor. Clear? So, for examples, we can say preference in repayment of unsecured loans to related parties. Suppose, many people, there are many creditors, unsecured creditors who have given loan to the business of the company, to run the business of the company. So now if the company pay the unsecured loans to a particular person, whether related, okay, I have mentioned it, but maybe it is unrelated, then such action of the company or corporate debtor or the management, whatever you say, is considered as a preferential transaction. Similarly, transfer assets to a creditor before others. Some money, suppose there are 10 creditors, but you pay the money for a particular creditor. So transfer of asset, that is, money is an asset of the company, to a creditor before others. When their term come as per the waterfall position, if you paid any one of them beforehand, that is also called a preferential transaction. But only one thing you keep in mind, that there should be an antecedent debt in order to be qualified for the preferential transactions. Payments or adjustment made towards the loans with debtors or creditors. You can understand, if I make the adjustment that I will receive something, you will receive something. I said, okay, fine, let's have the adjustment. You cannot do that. Once the CIP or once the insolvency process started, if you do it within the look back period, it will be considered adjudged as the preferential transaction. So what is the look back period for preferential transactions? For related parties, it is 2 years preceding to ICD, insolvency commencement date. All of you know that when the order of the adjudicating authority passed, admitting the insolvency procedures, that is called insolvency commencement date. And for other parties, it is related parties 2 years, and for other parties 1 year preceding ICD. Here I have mentioned something in red because I like to inform you that whenever you come to such a position where you have to determine whether it is a preferential transactions or not, please see the provisions given in section 53. So guiding principle for such transaction is section 53. If anything done by the corporate debtor which violates this provision, this violates the waterfall mechanism, it will be considered as the preferential transactions. section 43. Then undervalued transactions, it comes under section 45. It is mentioned that where the corporate debtor makes a gift to a person, enters into a transaction with a person with significantly less consideration by transferring assets, and such transactions has not taken place in the ordinary course of business of the corporate debtor, then it is called undervalued transaction. Just now I said that one of the main component of the preferential transaction is that there should be an antecedent debt owed by the corporate debtor. But suppose there is no antecedent debt, but even then the corporate debtor makes a gift to a person or entered into a transaction with the person with significantly less consideration by transferring asset. This is also an avoidance transaction because this is done something against the interest of its other stakeholders, and this is termed as the undervalued transactions covered under section 45. Example is this: the gifts made to the related or unrelated parties. If any company make any gift to the related, it will be undervalued transaction. Goods sold at a rate lower than the procurement rate. If the company purchased something at a particular amount and sold it to the other entity at a lower rate than the procurement rate, it is an undervalued transaction. Goods sold to some customers at rates lower than to the other customers. Suppose generally the selling price of the company is X. So now if the company sell any good to other customers at the rate of X minus 1, these transactions will be treated as the undervalued transactions. And the look back period for the type of transactions, undervalued transactions for related parties, again it is 2 years preceding ICD, and for other parties it is 1 year preceding ICD. Now we'll see the provisions for extortionate credit transactions. It is covered under section 50. Where the corporate debtor involves in receiving financial or operational debt at terms requiring exorbitant payment to be made. You understand? Suppose I am taking a loan at the rate which is much higher than the market rate. Whether related party, maybe related party or not related party. But this is termed as the extortionate credit transaction. Regulation 5 of IBBI CIRP Regulation 2016 states that a transaction shall be considered as extortionate where the terms require the corporate debtor to make exorbitant payments in respect of credit provided or the unconscionable under the principle of law relating to contract. It cannot be explained to the general guiding principles of a contract. Then these are called the extortionate credit transactions. Unlike the avoidance transaction, other avoidance transactions which seek the transfer of assets of the. Here I want to ask you a question. Can you tell me? We have discussed about the preferential transactions. We have discussed of the undervalued transactions. We are now discussing extortionate credit transactions. What is the basic difference between these three transactions? Anyone can tell? I'll just pause for 1 minute. Hello?
Exorbitant interest rates being charged, or this extortionate credit transaction, the ultimate aim is to exploit the company, sir.
But the other two also they exploit the company, no? Undervalue and preferential. You agree? I mean, other two also,
yes.
no? They
Yes,
are
sir.
exploiting the assets of the company.
Yes.
Anyone else?
In preferential and
Sir,
undervalue
intention, sir.
transaction, the funds are received outside. Funds go outside the corporate debtor. In external transaction, the funds are received by the corporate debtor.
Absolutely. Thank you.
Sir, intention is also one of the reasons,
The
one of the
intention
differences.
everywhere, the intention is to before the, I mean, to affect the interest of the other stakeholder. Intention is
Yes,
same, sir. Intention is same. Because
but
this is also called as the avoidance transaction. But
no,
what the
fraud,
gentleman said that
fraud.
here the money is coming to, and I am paying a higher interest. But in other two cases, the money is going out of my company from the hand. Hello, yes, tell me.
No, fraud is different from the other three things in the sense of intention. Other things are beneficial in terms of a particular company or individual, but fraud is at the cost of the company.
The fraud is different. I have not come to the fraud. Fraudulent transaction will come. But here I asked you what is the basic difference between preferential transactions, undervalued transactions, and extortionate credit transactions. For the first two, preferential and undervalued, here something new, it is a debit transaction. Debit means you are taking out something from the company and give it to somebody else outside the company. Okay. Here the extortionate credit transactions, it is a credit transaction. Something, some amount the company has taken, but the company has taken the money with an exorbitant higher rate. And that's why that's why the it affects the interest of the other stakeholders, the creditors, you can say. Because the company when pay the interest for this loan, they are paying more than the market rate. So this is the basic difference, because other two are debit transactions, but it is the credit transactions. I have mentioned it here also. I think it is mentioned in my slide also. Unlike the other avoidance transactions, which seek to address transfer of assets by the corporate debtors, extortionate transactions address receipt of credit by the corporate debtor. Although the ultimate effect is transfer of value outside the corporate. Either you have transferred the asset, you have transferred the asset in preference to the others, you have transferred the asset at a lower value, you have transferred your fund in terms of interest paid. So in all cases, the ultimate effect is the transfer of value outside the corporate debtor. That's why this avoidance transaction. Now, when you file the application, you will say that that extra amount of interest should come back. You cannot say that entire interest should come back. In this case, you can say that extra amount of interest which the corporate debtor has paid should come back to corporate, because it is a credit transactions made by the corporate. You see the example also, taking loans from parties at exorbitant interest rate and unfavorable terms and conditions. Supplier stipulating not only the bank lender, it doesn't applicable for the lenders only. Even the suppliers who supplied the goods, suppose the company's policy that they will purchase material on credit, but suddenly you find some transactions made by the company during this period, look back period, where they have given 100% or more than 150% advance. to the supplier for supply that money, material. The management can say, look, at that time our position was that, so the supplier has insisted us that you have to pay, you have to keep some money as a security deposit. No, you can see, we have to find the details of this thing. Definitely, yes. But it is a indication for the avoidance transaction. You are clear? So what I mean to say that suppliers stipulating, because this is totally an unfavorable terms. Why should the company pay him the 150%? Why company is procuring money for material from that supplier, and why company requires to keep the security deposit? Company doesn't keep any security deposit with any other supplier earlier. So supplier stipulating unfavorable terms and charging excessive price for credit supply during the time of financial stress of the corporator can also be established. Again and again, I am saying you have to found your opinion, then you have to find the evidence to establish your opinion. But it can be considered as the extortionate credit transactions, and for which the look-back period is 2 years preceding IC. Now, what you say, what you are saying, that fraudulent trading or wrongful trading. These are not fraudulent trading or wrongful trading. Now we are discussing the fraudulent trading or wrongful trading. It covers under section 66. Where any business of the corporate debtor has been carried out with the intent to defraud creditors. Here the basic intention of the corporate debtor that I'll make the form. Or for any fraudulent purpose, the adjudicating authority may, on the application of the RP, pass an order that any person who were knowingly parties to the carrying on the business in such manner shall be liable to make such contributions to the assets of the corporate debtor as may deem fit. So, if any fraudulent trading or wrongful trading is found, if the RP make an application before the adjudicating authority on establishing his claim, his submission, the adjudicating may pass the order requiring that other person should make the necessary contribution. He cannot take the plea that, look, this is a business transaction between us, because the very intention of that business transaction is for the fraudulent purpose, is to defraud its creditors. So that other person has to make the contributions as directed by the adjudicating authority to the corporate debtor. Such transactions are happened before insolvency commencement date, and these are happening before insolvency commencement, where director knew or ought to have known that there was no reasonable prospect of the avoiding the corporate insolvency resolution process in respect of such corporate debtor, which we have already discussed in twilight period. All these fraudulent transactions, the management or the board of directors, they undertook when that twilight period starts for the company. Such director or partner did not exercise due diligence in minimizing the potential loss to the creditors of the corporate debtor, and they undertook that transactions. The example of manipulation in the books of accounts or other records of the corporate debtor to deceive the creditors. Suppose, they falsify the records. So who is benefited? The management, the director. The adjudicating authority can direct the director that you refund, that you make the contribution towards to the corporate debtor for this resolution process. So this is one of the examples of the fraudulent transactions. Manipulation in the books of account or the record or other records of the corporate debtor to deceive the creditors. Use of forged documents and records to obtain sanction and disbursement of credit facilities. Bogus exchange bills, sale bills for discounting, export and import bills for incentives, siphoning of inventories incentive siphoning of inventory and stock of the corporate debtor, but showing increased consumption by falsification of books of account. So these are many methods the company indulges during the twilight period to get extra facility from the bank. And these all are called as the fraudulent trading or wrongful trading, covered under section 66. And friends, for this fraudulent trading or wrongful trading, there is no look back. It is open. If any fraud is done, anytime it is done, you can find it out, you can file your application and submission for the necessary contribution towards the fund of the corporate debtor to run the insolvency resolution process. There is no time limit. Clear? So let's take some examples on the avoidance transactions. I have taken on situation where X Limited gone to CIRP and insolvency commencement date is 15th July 2020. We have discussed all the 4 transactions, no? Profit transactions, and also we have seen the look back period within which this transaction, if happened, then the avoidance transaction application can be filed. So first example is that X Limited transferred goods worth of rupees 500K, 5 lakhs, to Y Limited. Y Limited is an unrelated party for settlement of operational debt of rupees 1000K during financial year 2020. Okay. Financial 2020 means financial 2020 means April 1st April 2019 to 31st March 2020. Okay, and this has gone to ICD has started on 15 July 2020. So look back period for all the things are applicable, though it is not unrelated. So firstly, it is a preferential transaction. You agree or not? Hello? Hello? Can you tell me whether you agree or not? This is a preferential transaction, I say.
Yes, sir. Yes, sir.
Why? Why?
He has transferred to Y. He can sell to anybody, sir. Correct? A, B, C. The amount, the product has been sold by X to Y.
Hmm. So why this preferential transaction?
No, he has transferred to Y for settlement of operational debt. Oh.
Absolutely right. Absolutely right. I just want to hear this word from you. Operational
Yes,
debts.
operational debt
Operation,
of
if you
1
see
lakh.
that waterfall mechanism,
Yeah.
much below. Isn't it? First the secured creditors. So since it is transferred for the settlement of an operational debt, it is a preferential transaction. It is an undervalued transaction also because they have transferred 500K materials for an operation of 100K.
For 1 lakh.
Yes. So definitely undervalued. Okay.
Yes, sir.
And also defrauding other creditors, because there are other creditors which we suppose, we presume, and only one particular creditor is given this facility.
So moreover, because it is undervalued, to the extent of about 4 lakhs, X Limited is losing, it could have used for payment to other creditors.
Absolutely. I mean, that's why I'm saying that because of this, because through this transaction, X Limited has defrauded the other creditors also.
Exactly, sir. Absolutely right.
Yeah. And definitely it is a fraudulent and wrongful transaction. No doubt about it. If the intention is the defrauding the others, so it is a fraudulent transaction.
Yes, sir.
So all these sections 43, 45, 49, 66 are applicable to this particular transaction.
So
Okay.
one small doubt.
Yeah.
X Limited transferred goods worth rupees 100K to Y Limited, unrelated for a
500K.
settlement of, no, I'm saying if it is 100K for a settlement of 100K operational debts, will it be considered as a preferential transaction?
Of course, yes. Because if I said that the guiding principle is the section 53. You see section 53 waterfall, who will get the money back from the recovery first?
First of all, secured creditors, workmen, and other things.
Is it a secured creditors?
It is not, but one of my case where court was saying it has been done in normal course of business.
No.
That is what they have read, because he owes 100K to him and the good transport is also 100K. Just because he doesn't have money, he has transferred goods worth rupees 100K, and it is a normal course of business, is what some of the experts were reading it. While I also understand it is a preferential transaction, because there is no question of transferring goods. He has to pay the money. Money. If it has been paid as a financial transaction, then it is a financial. Then it is a preferential transaction. Instead of transferring goods, he has paid money.
Yes.
That is
Not
where somewhere
money.
I think
there is a precedent debt owed by the company, and for that he has paid it. Transferred goods.
No, for that,
whatever paid, he has transferred the asset. Whether money is also asset for the company, isn't it? So he has transferred asset. You just keep it in your mind. We have some case laws where it is categorically mentioned which will be considered as the, in fact, the Supreme Court has given a very well definition of in the course of normal course of business. What is considered as the normal course of business? Just keep it in your mind for the time being. When we will discuss the case law, if it is not answered, you please raise this again. Okay.
Sure, sir. I still have doubt in this. I will raise.
When we will discuss the case laws, I think it will be clear. If not, then we will discuss.
Sir, I have one more point to what Ms. Rajalakshmi was saying. She says normal course of business. Here, CIRP is commenced on 15th of July, right?
I'm sorry, come again.
The CIRP has commenced on 15th of July. So where is the question of normal course of business? You're able to hear me, sir?
No, look back period is 1 year. Look back period is 1 year. In that 1 year, he has operated, and for because of see, all operational creditors cannot be paid based on this thing, depending upon how the emergency situation arises. In normal course of business, he would have preferred to pay. As per this explanation, I'm not talking about 500K. That is definitely wrong. If 100K payment to the operational creditors should not have been read as a preferential transaction, because otherwise all 1 year payment to operational creditors should have been avoided. Is that the IBC? So that is where is my question.
I'll definitely answer it. Just give me some time when we go to that slide. And for answering the other gentleman's answer question, 15 July is the ICD, agree. Maybe this 100K is given on 1st April 2020. It is a preferential, because it is within, that's why I said it is within the look back period. If it is not unrelated party, then you have to see 1 year prior to the ICD.
Correct.
So 1st April is 1 year prior to the ICD. You can very well, if you can establish that is a preference transaction, it will come on.
No, he is a creditor and he has been paid.
But what question you have raised, that whether it will be considered as the normal course of business, I will give answer. I will give answer, not only me, I will give answer to the case laws.
Sure.
Okay. Now take the example 2. The same goods, that is this 500K, which they have transferred to Y Limited, were sold to Z Limited by Y Limited, a related party of Y Limited, at rupees 120K in the same financial year 2020. But here you see, this is not affecting the balance sheet of the corporated. So it doesn't affect any of the provisions of the avoidance sanction. But this information, I said that you also know that as per that regulation 35, which we will see also later, first you have to make an opinion about such transaction, then you have to establish. So if you have this information, maybe this information is very, very vital, very, very important in future to establish whether this affects the avoidance transaction or not, which you will see just now. So for the time being, this is not, it is off the balance sheet transaction of CD, and it will not cover any of the avoidance transactions as per the code. Now, Z Limited sold the same goods to Mr. M, a director of X Limited, at 150K. So if you have that earlier information that Y Limited has paid to its related party Z Limited at 120K of the goods it has received from X Limited, and subsequently Z Limited sold it to Mr. M, who is a director of X Limited, at 150K. Definitely this transaction, the chain of this transaction is made to default the creditors. Section 49. You agree or not?
Yes.
And also it is a fraudulent transaction under section 66.
Correct. Correct.
So whenever you file your application, you have to be very meticulous. You have to first ascertain, then you have to establish the evidence. You have to establish all the information. How you are saying that this is called for an avoidance transaction, because you have that information that Y Limited sold it to Z Limited at 120, and subsequently Z Limited sold it to Mr. M, director of X Limited. Whatever may be the price, maybe higher price. I mean, it doesn't matter. But the basic intention of the corporate, who is corporate? X Limited. Basic intention of the corporate debtor X Limited was to default its creditors through a zigzagging way. And example 4, X Limited provided loan of INR 150K, that amount, in the financial year 2017 and 2019 respectively, to purchase this material from Z Limited. It is nothing but the fraudulent transaction. The twilight period came. Management knows that there is no scope to avoid this insolvency proceeding. So X Limited provided loan in two phases, one in 2017 and another in 2019. They entered 150K to Mr. M, who is the director of X Limited, and through that money, he purchased the goods from Z Limited. So it is nothing but a fraudulent transaction undertook by the corporate debtor. Okay. So in this way, you have to determine the avoidance transactions for filing the applications for them. Any question you have, you can ask me.
Sir, whether it is always through forensic auditor, means with the help of forensic audit,
of course,
or RP can file it based on his knowledge and skill?
No, sir. Actually, you know what's happened? There is no provision in the code that RP should appoint any forensic audit or transaction audit to establish the avoidance transactions. At the same time, many jurisprudence are there where it is admitted that maybe it happened that RP doesn't have that skill. You know, it requires specific skills for determining these avoidance transactions, because it depends upon the nature of business. Just now, one said that whether it will be considered as a normal course of business or not. So nature of business of the corporate is very important. What sort of material it is very important. Whether it maybe it is a perishable good. I don't know. I mean, I'm just giving all these things. I mean, alibi out of my hat. So it is said that maybe RP is not in a position to ascertain these things, then so he can appoint the forensic auditor or transaction auditor to determine RP to कर लिया from his mind that oh, something garbar hai. There is something which is called avoidance transactions. But to establish the thing, he may appoint a transaction auditor or the financial forensic auditor. But the point is that, and for that, RP has all power. He need not to go to COC for the approval of appointment. But the thing is that the payment for the fees to be done by COC. So definitely, yes, RP should discuss these things in the COC meeting, and RP should convince COC that this requires the transaction audit or forensic audit. You get your answer? Hello? You get your answer?
Yes.
Thank you.
That is right. Yes.
Sir, to add to it, I think you are right that it doesn't mandate the RP to definitely appoint an forensic auditor if he is able to establish with the documents. Right. I think there is no need to go to forensic audit. Only when he is just foreseeing that there might be a forensic for a fraudulent transaction, but not able to identify with the proof, then a forensic auditor is will be helpful. I don't think jury.
Yeah, madam, another thing, you know what's happened? Even if RP appoints a forensic auditor or transaction auditor, the responsibility of establishing the evidence before the adjudicating authority lies on RP. RP cannot take the shelter that I have relied on the report of the forensic auditor or transaction. You get my point, what I mean to say? So RP has that ability to understand the report of forensic auditor. It requires very close interaction with the forensic auditor or transaction auditor. There are many cases where the evidence transactions are rejected, application for evidence rejected, because adjudicating authority is of the opinion that RP simply just attach the report of the transaction auditor or forensic auditor. It has not given its own perception on the report. Yeah, why it is really called as the evidence. So that much ability RP should have. Maybe he will take the help of the expert, but he also should understand what the report says. Because I mean, there are not only this financial forensic report or transaction report, valuation. This happens for the valuation report also. There are so many disclaimers. This has happened. We have not checked this. So RP should understand. Should talk to them. They look whether, or at least the RP should understand whether this will suffice for his purpose. When he will file the application before the adjudicating authority, whether adjudicating authority will be satisfied with his view that this is called this is a avoidance transactions, and for which the necessary order to be passed. Clear?
Yes, sir. Sir.
Yeah. So, friends, I told you earlier that avoidance transaction is completely a different process, according to me. And it can be considered as stage number 3. And I made this comment because of the provisions of section 26, which talks about the application of avoidance transactions not to affect the proceedings. It further says that the filing of an avoidance application under clause J of subsection 2 of section 25 by the resolution professional shall not affect the proceedings of the corporate insolvency resolution process. Also true for liquidation process. You know what's happened? Whether you will file the avoidance transaction application or whether you have received the order for your application, it has no impact. It cannot stop the proceedings of CIRP or liquidation. So it is a totally independent. At the same time, very, very important aspects. I say it is stage 3. According to me, there are 3 stages for the conducting the insolvency resolution process. One is CIRP, second is liquidation, and also this application for avoidance transaction is also one of the stages for this process. So I think you will appreciate my saying that the application of avoidance, because you know what's happening, there are case laws also. Maybe the order has not come after before the approval of resolution plan, but it doesn't take away the application. I mean, it will not stop you for pursuing your application towards the avoidance transactions. We'll see later. So I again maintain, I reiterate that avoidance transaction application is a parallel activity compared to CIRP. It is not a part. It is not a part. We very loosely say that, okay, avoidance is a part of CIRP. Avoidance filing avoidance is a part of liquidation. No. According to me, again, I am saying it is my perception. Filing avoidance application, transaction application is a parallel activity in the entire process. Okay. So the other relevant provisions for the avoidance transactions is that section 25(2)(j) we have already said, discussed, of IBC made it the duty of the RP to file application for avoidance transactions in accordance with chapter 3, if any. Chapter 3 consider, I mean, given all the provisions for the various profit transactions. Section 35(1)(j) of IBC mentions the power and duties of liquidator to investigate into financial affairs of the corporate debtor to determine undervalued or preferential transactions. The filing of application doesn't stop with the completion of the CIRP process. Even during the liquidator, as per section 35(1)(j), can find out the undervalued avoidance transactions and file the application towards it. Section 36(3)(f) of IBC mentioned that the liquidation estate shall comprise of inter alia any asset or its value recovered through proceedings for avoidance of transactions in accordance with chapter 3. If any avoidance transaction application is filed by the liquidator, and if the necessary order is received, the money or the contribution which has been ordered to give it to the corporators will be formed the part of the liquidation estate where the distribution will be made. This is mentioned in section 36(3)(f). So this is regulation 35A. I think all of you are aware of this, of IBB CIRP regulation 2016. On or before 17th day of ICT, the RP shall form an opinion whether the corporate debtor has been subjected to any transaction covered under section 43, 45, 50 or 60. So firstly, the RP has to form an opinion whether there exists any avoidance transactions, and it has to be done on or before 75th day of insolvency commission day. So first, the idea that yes, maybe there is some possibility for avoidance transactions in the case of this corporate debtor. Where the RP is of the opinion that the corporate debtor has been subjected to any such transaction, he shall make a determination on or before 150th day of ICT. So after the opinion, forming the opinion, it is determination. You have to determine that yes, what you have decided is correct. There exists an avoidance transaction. So, and this such type of determination is done before 115th day of ICD. Here you can take the help of the transaction auditor or forensic auditor, though it is not mandatorily mentioned in the, but it is at the same time it is understood, and their main case laws are there, that maybe RP doesn't have that requisite power, I mean capacity to make the determination. But the responsibility is with RP. Where RP makes a determination, he shall apply to the adjudicating authority for appropriate relief on or before 135th day of IC. So after forming the opinion, determination, within 135th day, the RP has to make the application to the adjudicating authority for appropriate relief. The creditor shall provide the RP relevant extract from the audits of the corporate data conducted by them, the stock audit, transaction audit, forensic audit, etc. And you know, for this purpose, not only RP has to find out the evidence, it can it may get the evidence from the creditors also. Because you know, sometimes what's happening when creditors, I mean, they offer the loan to the corporate debtor, they take some document from them, or they conduct the stock audit, transaction audit, maybe forensic audit also. Prior to the, it becomes NPA, or prior to they are filing the insolvency application. So if it exists, the RP can take the relevant thing also. It is not that the RP has to determine. It can take the document from the creditors also for the determination purpose. So there are many various ways, means and ways the RP has to develop how to make the necessary determination before filing the application. So this timeline, I think all of you are aware, is given in the regulation for the avoidance transaction, filing the avoidance transaction application. Regulation 39(2) of IBBI CIP Regulation 2016, it says that RP shall submit to the COC all the resolution plans which comply with the requirements of the code and regulations made thereunder, along with the details of the following transactions, if any, observed, found and determined by him: preferential transactions, undervalued transactions, extortionate transactions, fraudulent transactions, and the orders, if any, of the adjudicating authority in respect of such transactions. Friends, this also proves what I said, that avoidance transactions is a parallel activities. It is not a part of the CIR process, because this particular regulation said when RP submits before the COC all the resolution plans, all whatever the resolution plan he has received, he has to submit it for the approval. At the same time, he is required to submit before the COC the details of the avoidance transactions under section 43, 45, 40, 66, if any. If he observed any, then he has to determine it. He has to file the applications. So every document he has to file before the COC along with the resolution plan. Had it been a part of the CIP process, this particular requirement will not be there. They are only the requirement that you submit the resolution. Since it is a separate activity, a separate stage of activity, so this regulation 39(2) stipulates that RP is required to submit the details related to the avoidance transactions and the order, if any, received from the adjudicating authority at the time of submission of the resolution plan before COC. You get it? Now we'll see the role and responsibilities of the RP, because you know we have seen this regulation 35. how the things to be conducted. Now this chart shows that how RP will act to achieve these responsibilities. What is his role towards the filing of avoidance transactions? So first, he has to obtain through inquiries. Maybe he will discuss with the personnel of the corporate debtor. He can go through the books of the corporate debtor, records, all information, because nowadays you can have the information from the public domain also for the corporate debtors, or any other sources like the report, if the banks creditors have transaction audit, stock audit report, all these things. So first of all, the responsibility or role of the RP is to obtain all this information, all this data. Then he has to verify this data, this information, these records, and he should look for the red flag indicators. Will come what is called red flag indicators. So the very, very important thing for forming his opinion about the existence of the avoidance transaction is to find out the red flag indicators out of the information he has so gathered. And only one thing I really want to mention you, the time frame is very short. It is only the 75th day, within 75th day of ICT. So after you determine your mind that yes, there exists some avoidance transaction, then what's happened? You have to review these things, all these materials, all this information, all these records. You have to have a proper review. And for that, you have to conduct and conclude avoidance review through transaction audit or forensic audit. Clear? So first you have to obtain, you have to look for the red flag things, and then you have to see that really this red flag leads to the, you have to get the evidence that these red flags things are really the existence for the avoidance transactions, and this can only be done by conducting or concluding the transaction audit or forensic audit. Or if you have any other means, there is nothing is mentioned in the code. If you have any other means, you can apply that. But you have to determine the existence. And then the final stage is the application. Application for the value maximization, because if you get the order to get back those money in the corporate debtors account, definitely it will maximize the value of the asset value of the corporate debtor. Filing application before the adjudicating authority, and for this purpose you have to file the necessary application before the adjudicating authority. So this is this chart shows the how RP will function towards the determination of the avoidance transaction. Now we see what are the red flags indicators. I told you already that when the twilight period comes, the general tendency of the management or the board of directors or the key people is to flout the rules, flout the guidelines, flout the policies of the company. And many things they do, they have done under the carpet So as for example, red flag indicator that non-maintenance of books of accounts are produced the same before RP. Maybe you will see that after a certain period there is no books of accounts available with the corporate data. or nothing is produced before you. You are only getting certain, you are getting the account statement or details of accounts up to a certain period of time, not after that. Surely this is a red flag indicator. You agree? Surely there may be something which they tries to hide, and that's why they didn't maintain any books of accounts. They have destroyed their records. So non-maintenance of books of accounts or produce the same before RP is a red flag indicator. Non-maintenance of secretarial books and records, absolutely yes, because many records are maintained in the board resolution, shareholder resolutions. So if it is not maintained or if it is stopped, the maintenance of these records are stopped, definitely there is something. And this is also a red flag indicator. In such cases, the endeavor should be made by the RP to gather information as far as possible from the outside sources, maybe from the auditor, maybe from the MCA site, tankers, but surely there is something. That's why corporate debtor has stopped it. High value of inventory certified by the management and not by the auditor for consecutive years. Huge inventories, and it is only certified by the management. No auditor certificate is received. So definitely is something is there. I mean, you don't know whether the inventories are really exist or not. You have to have a proper checking of inventories. Maybe this has siphoned out from the corporate data. Again, a red flag indicator. Audit observation on non-recoverability of loans and advances. Suppose you see the financial report of the auditor's report of the corporate debtor and found that some loans and advances auditors is mentioning is not recovered years after years. Maybe some fund has been diverted to others, to related parties, maybe not related parties, but for definitely something has done to default the creditors. Otherwise, the normal scenario of this this loans and should be recovered. Again, a red flag indicator. Customers payment directly to vendors by an unauthorized third-party agreement. Definitely yes. Red flag indicators means this is a preferential transaction, because you have made an unauthorized third-party agreement where you said your customer, you do one thing, I will supply you the material, but you need not to pay me, but you directly pay it to that other party, third party. Of course, the avoidance transaction. Red flag indicators. High value of disputed and undisputed statutory dues shown as contingent liabilities. Yes, red flag indicators. Any material adverse information obtained from public domain. Nowadays, I mean, during the era of internet, lots of information we can have from the public domain. And if any material adverse information you obtain, you can consider it as a red flag. Whether it is actually, I mean, something has happened or not, that we can establish after the determination. But for forming of opinion, you will only see that whether there is a red flag indicator or not, and this is considered as a red flag indicator. Information obtained from forensic report done by FC's past or present. I told you that generally banks sometimes they conduct the forensic audit or transaction audit, and if you get the report, if you can have the report, you can find out the red flag indicators, which transactions are mainly mentioned in those forensic report or transaction. Provision of corporate and bank guarantee to related parties and or third parties by CD, especially when they are not in the same business. Why? I mean, definitely some advantage we have given. Gift, red flag indicator. payment of unsecured related party loan while debt of secured creditor is outstanding. Surely, I mean, preferential. Payment unsecured FC obtained through personal guarantee of director. For some loan, the personal guarantee has been given by the director, and you have paid that unsecured financial creditor, but unsecured. Just because that the personal guarantee is given by the director, it is a preferential transaction. And if you found such things, it is a red flag indicator. You have to go to the details of the transaction. Write-off of debtors and advances without justification or reason or efforts to collect may be considered as a gift to the party. So write-off debtors and advances without justification, reason or effort to collect, maybe you have given a gift. That's why you just write off the advances. Sale of unsold inventory by real estate company before CIP at a price much less than market value, undervalued transaction. Red flag indicator. Taking unsecured loan from parties at exorbitant interest rate or unfavorable conditions. If these things are located in the records or information, if any information is received for this, you can be sure that there is something, because this is extortionate credit transaction, and this information or this entry in the books of records is a red flag. Making entries of bogus expenditure in the books of accounts for the diversion of funds for personal gains of the management. Red flag indicator. So it is the responsibility of the RP to claw back the money lost through avoidance transactions. We have already discussed these things, and that's why I said when I start my presentation that nowadays there are many disciplinary committee order or the case laws against the RP, since they didn't fulfill this responsibility of theirs. Because this clawback, the money lost, should come back to the corporate debtor, and for this only the responsibility is the RP. The person who has the responsibility is RP. Section 47(2), friends, I really want to say that this is a draconian provision in the entire avoidance transactions process. It stipulates that where the adjudicating authority, after examination of the application made under subsection 1 by a creditor, is satisfied that undervalued transactions had occurred, and B, liquidator or the resolution professional, as the case may be, after having sufficient information or opportunity to avail information of such transactions, did not report such transactions to the adjudicating authority, it shall pass an order restoring the position as it existed before such transaction and reversing the effects thereof, the manner as laid down in section 45 and section 48, requiring board to initiate disciplinary proceedings against the liquidator or the RP as the case may be. So if it's happened where there is information or there is an indication that the avoidance transaction of the existence of avoidance transactions, and a creditor filed an application before the adjudicating authority against the RP stating that he has not, RP or liquidator stating that they have not performed their responsibility by making necessary application for restoring this avoidance transaction. In such case, firstly, the adjudicating authority will pass the order to restore the position and to return the money to the corporator, and also requiring the board to initiate a disciplinary proceeding against the RP or the liquidator, as the case may be. This is a very serious provision, friend. So that's why I said it is a very, very important subject we have chosen for discussion in today's session. We have to be very careful about it. So now we'll go for the case laws. Do you have any questions here so that I can answer?
Yes, sir. I have one question, sir.
Yeah, tell me.
Sir, actually, my question is, being an RP, there may be situations where the RP is continuously making efforts to determine the avoidance transaction, and somehow maybe there are certain information which he has got the information, but the auditor, the forensic auditor, for example, has not included in his report. But still the RP has sufficient evidence. So I believe the RP can proceed filing the application. This is my first question, sir. Number two, sir, sometime it happens that as you have also mentioned, that the directors, they actually, the RP comes into picture only after the passing of the adjudication authority order. Correct. But the directors are working for creating and safeguarding their interest since long back, when the account was turned, maybe 2 years back or so.
Right.
Because I have personally come across many such cases where the directors, suspended power directors, were involved in changing the record, shifting the records here and there. And when RP comes, they just simply have a meeting, because sometimes they are very smart and they say कि भाई ये सारा record आपके पास पड़ा है. And there is no list of files and anything. Then the working of RP starts. And that takes time to unearth really big transactions. So what I'm facing, that my process of determining the transaction is continuing. So I filed 2-3 applications, still some more information have come to me. Then I'm checking personally. Then I determine, okay, now let's file the application on this account. So what is your view on such process, such conduct, and how to ensure that we as RP are not at fault?
Yeah, good question.
Yes, sir.
Acha. Firstly, you said that what you said, that forensic auditor didn't mention any a transaction.
Yeah, yes, sir. So they have not covered. Yes.
Yeah. Look, I already told you that there is no provision in the code that RP has to work according to the report of the forensic auditor or the transaction. RP has the sole discretionary power to file the application. Even not getting any report from transaction forensic auditor or transaction auditor, RP, if he is confident, if he can determine, this word is very important, sir. You have to frame your opinion and you have to determine the transaction. So if you are really able to determine the transaction before adjudicating authority, you are free to file your application, whether it is mentioned in the forensic auditor's report or not, doesn't matter. Clear? But again and again, I am cautioning you, I think you can talk to the forensic auditor why they have dropped this matter. You can have a discussion with them. What make them dropping this matter from their report? Why they are not considering it as avoidance transactions? Because the entire thing, you are responsible, not the transaction auditor. If something happens, what I said, that section 47(2), if some creditors go to adjudicating authority and file the application, look, there is an existence of avoidance transaction and RP didn't file the application for that, You cannot take the plea. They look, I have made a forensic audit and they didn't cover it in their order. That's why I didn't find. No. Court is made RP sole because you know. Just a minute. If you see this slide, I can just a minute. Okay. Because if you read this slide, that such responsibility solely rests on shoulders of RP, as no one else RP can file such application. Court has given the authority only to file the RP only to file the avoidance transaction application. You get the answer? So I suggest that you once had a talk with your transaction auditor, ask them why they didn't cover it. If you find that, look, what they are saying is correct, you can also, act accordingly. But if you find that, okay, what they are saying is not correct, and if you have sufficient evidence in determination of that avoidance transaction, you can go ahead with the application, because the ultimate responsibility lies on you, with you, not on the transaction.
Yes, sir. Understood, sir.
Okay, I have one question.
Yeah.
Suppose a PUF application is filed with the adjudicating authority by RP or a liquidator, and the order is also passed by adjudicating authority ordering the respondents to pay, say, 20 crores.
Yeah.
Now, if they don't pay, and whose responsibility is there to recover that money?
It is, you have to file application before adjudicating authority. If you have the clear-cut order from the adjudicating authority that they have to pay,
but if the respondents don't pay,
and if they don't pay, you inform the adjudicating authority. Don't sit on it, please, because it is again your responsibility. And time and again I'm saying, so immediately you file an application before adjudicating authority. Okay, you can wait for a reasonable time frame. Suppose order is received today, you cannot
because
expect
this money goes ultimately to COC, the avoidance transactions.
Sorry?
This, in almost all the cases, this avoidance transaction money goes to COC only, financial creditors.
Yes.
So, or can RP or liquidator assign this order to COC?
No. Why? CRP process
not
or
readily recoverable assets.
Process over or not yet over?
Pardon?
Is it continuing or not yet over?
No, I'm just asking a question.
No, your process, your activities is over now. It is still continuing.
In both the cases, suppose the process has stopped, process has finished, and order comes after that.
Order has after that, then you I think you have to talk to COC, but it is you, because I'll show you a case law. Venus recruiter, where division bench categorically said that even if the resolution process is over, RP has the power to continue with the application. So I think it is you who will file the application before the adjudicating authority. You can inform them that, look, this has happened. I got the order after the completion of the resolution process. Either, I don't know, whether you have received the resolution plan or liquidation is completed, resolution is done. So you inform the creditors, financial creditors, that, look, this order has come and I am going to file the application. If you have any requirement of fund, if you require that money is a criteria, you make a prayer in the application. So the suitable instruction should be given by the adjudicating authority to pay you the money for the pursuing this application. But according to me, it is you. It is not the COC. They will file the application. You can have a talk with them. If they say that, okay, I will pursue you, you need not to pursue, I think you take it by writing from them. They give me in writing that you will say that I will pursue you, not you. If the process is over, again I'm saying, if the process is still continuing, it is you. You can discuss it in the COC meeting, you can inform them, or if it is liquidation, you can discuss in the SEC meeting, you can inform them, you file the application. If fund is required, you make necessary prayer in the application itself. For this money can be paid to me. Clear?
Yeah.
Okay. And your next question, I mean, where you said that all the books of records, he said it is with you, we have given everything you. Sir, firstly, if really it is so, you feel that they are not cooperating with you, immediately file application under section 19.1 section, you please file the application. You must have the record that you have informed the adjudicator. Also, you inform COC that this is the position. They are saying that everything is with me, but they have not cooperated with me. So I am intending to file the application under section 19. You must have the record. If something comes to you in future, you have to establish that you have taken sufficient step against this situation.
Sir, okay. I have filed the application 19.2 also, and I have filed the application for exclusion also based on this ground only, because even after the 4 or 5 months, the directors have not responded and they are not replying to my emails, and I am making the list of files and discovering the record, which is taking time. So I have evidence also that the statutory auditor also was not responding. He was acting in connivance with the suspended directors. I have filed a complaint also against the statutory auditors in the Institute of Chartered Accountants from Prism. All those things I have done.
Now you have we have made the complaint, file section 19 application against the statutory auditor also.
Yes, yes, sir.
Very good.
92,
and you got
92.
the order. You got the order.
No, but unfortunately, the matter could not be heard even for 4 months, sir.
You make the mention, you know. You make the mention.
Yes, sir. Yes, sir. We are trying to bring it to the
make the
notice.
mention. They said this has happened, and again, I suggest you one thing. You talk to your lawyer. You can file an application, or you can mention it in your report, in your progress report, that because of these things I have filed all this application before NCLT, it is pending, but as a result of which the filing of avoidance transaction is pending even after that 135 day. I have some case laws where these things are discussed, but it again I am telling you, it depends upon case to case basis. Don't think that the court has given order in this particular case, court will also give the same order in my case. No, sir. No. How you represent before the court, what thing you deliver in support of your application, court would only see those things, and again it can happen in other way also. Suppose in a particular case, court has denied that application, rejected that application. It doesn't mean that your application will also be rejected. I have that experience. In some cases, I got the order in my favor, where in earlier cases, the same bench has rejected the application. You have to prove, I mean, you have to substantiate it. You have to tell them, they look, this is the way I am here. Yes, Mr. Monish, you have any question?
Not a question, but with your kind permission, a suggestion to my lender friends.
Yeah, tell me. Sure.
Okay. I find there is a section 70 in IBC, which is totally unutilized by IPs. So that is punishment for misconduct in CIRP. And it clearly says if during CIRP the directors or their KMPs are not supplying you documents, that IBI can file a criminal proceedings before them. But the procedure is like that, and RP has to move an IA before bench NCLT where his case is being dealt with under section 70. It's a very simple 3-page application. Move an application, get an order or instructions to IBBI to launch a criminal proceedings. This section is not being utilized by RP. RPs are not utilizing the powers given to them by the court. You start using it, everything will fall in line. Thank you.
But this application to be filed by IBBI, I believe.
No. Achha? RP has to file an IA before NCLT can issue directions to IBBI.
I have to check. Yeah. No, right. I mean, they are. That's why I'm saying that don't sit on the things, because it is an evolving code. Anything and everything is possible, and you have to cover up yourself, because code is very clear that you are responsible for. RP and liquidator is responsible. So, but you are not at fault. So how to cover up yourself, it is your responsibility or your role to find it out. There is no, I mean, what should I say, hard and fast rules that, okay, you perform in this way, that's why you will not be in trouble. No, you have to find it out, and you have to talk to your lawyer also.
Sir, one question was regarding the timelines. For example, sir, 135-day limit is there, and in some cases the RP is able to file application post that timeline. So has that any adverse implication in the fate of this application, or what is your view, sir?
Sir, there are many case laws. I have gathered some case laws on this, which we will discuss, where they said that, look, this is a directory, but if it is established that you are just sitting on it, you have not taken proper action, you can't expect that court will come and say, no, okay, it is mentioned earlier that it is a directory, not mandatory, so we will just condone your delay. No. That's something that, since it is, what is the beauty of this code? Beauty is the code is not, it is not restricted to only the wordings of the provisions of sections and regulations. The case laws which are pronounced, which are really settled by now, has very much impact on the petition filed by the persons before the adjoining authority. But at the same time, it is purely on case-to-case basis. I can show you. I have the case laws where it is categorically seen. If they like that, in your case, that where the RP liquidator, in that case liquidator is mentioned, is not getting. He has come to the picture later on. He has come to that information that there is an avoidance transaction where there is 150 35 days over. So what he will do? Because the basic purpose of the avoidance transaction is to get back the money to the corporate debtor. And it is seen that this, through the resolution plan, also for the liquidation also, when corporate debtor gone to liquidation, these financial creditors, they undertook huge haircuts. So the basic intention of the code is to provide them more money through these avoidance transactions, through the filing application against the personal guarantor. All these things have come into picture because it is seen that at the real field, the financial creditors losing money. Mostly the financial creditors are banks, and banks are losing money means it is public money. So definitely we will get the support from the adjudicating authority, provided you establish your case. You have to establish your case properly.
Thank you, sir. Thank you.
So can you have 5 minutes break or 10 minutes break before you start? Because I have some case laws to show you.
10 minutes would be sufficient.
10 minutes or 5 minutes?
5 is not sufficient, sir. 10 minutes.
Okay, 10 minutes. So we'll gather up to 10 minutes. So can we start now? Hello? Hello?
Hello.
Yes, sir.
Yeah, can we start?
Yes, sir, we will start.
Yeah.
Yes, sir.
So here I have compiled certain case laws for your reference. Friends, as I said that IBC is an evolving code and many matters have been settled or decided based on the judicial pronouncements. So again and again, it is my suggestion that you have to be well conversant with the fact, with the provisions of the sections under the code, its regulations, as well as the case laws for the petition you have filed in order to obtain the desired outcome from the hearing. So here I will discuss with you certain case laws in order to show you that how the judiciary reacted for the avoid for the on the for the applications filed on avoidance transactions. The first case which we will discuss is the JP Infratech versus Axis Bank. This is also you know as the Onit Jain case. It is the most important case, and I am sure that all of you are aware of this case. But I request you that because you know I have given the excerpt of the order or the case. But therefore I request all of you, please go at least one time through the entire order given by the NCLT, NCLAT and Supreme Court. It will clear many issues which we have on the subject. So, you know, the fact is that in this case, the Joy Prakash Associates Limited, Joy Prakash is the holding company of JP Infratech Limited, JP. Joy Prakash received working capital from certain banks. JP put parcels of land under mortgage with the lenders of Joy Prakash. These transactions created security interest benefiting Joy Prakash. Joy Prakash took the loan. JP has given a parcel of land as the security. And therefore, benefit goes to Joy Prakash. Joy Prakash had agreed to provide certain services to JP, thus JP owed operational debts to Joy Prakash. As Joy Prakash was an operational debtor to JP and would have stood much lower rank in priority in case JP went into liquidation, as such transfer of land put Joy Prakash in a beneficial position in relation to other creditors in terms of section 53 of the code. Clear? If you have any difficulty understanding, just let me know. Further, the transfer stroke mortgage was made within 2 years of initiation of CIRP. Joy Prakash being a related party, these transactions fell within the look-back period mentioned under section 43 of the code. Further, these were not carried within the ordinary course of business as JP was under tremendous financial stress. At that time, someone of you asked me the question of ordinary course of business, what does this mean? So I request him that you please very carefully listen to this case law discussion. Further, these are not carried out, means that mortgaging that land within the ordinary course of business as JP was under tremendous financial stress at that time and therefore could not have been providing mortgage to secure finances of its holding company. So this is the fact of the case. So what are the issues? The key issues in this case were whether such mortgages created by JP for loans available by Joy Prakash, the parent company, amounted to preferential transactions under section 43 and 44 of the code, since this allowed Joyprakash to avail a significant higher amount of lending from a large number of creditors. Because of this mortgage, Joyprakash got the huge amount of loan from the creditors. Also, whether the look-back period of these transactions will be considered for 1 year, as argued by Joyprakash that beneficiaries of these mortgages were the creditors in whose favor these were created. So they are not related parties. So whether the look-back period will be considered for 1 year, because 1 year was over when this application was filed. Further, whether Joyprakash could be recognized as a financial creditor of CDJP on the strength of the mortgage created by CD as collateral security of the debt of its holding company, Joyprakash. So with these issues, the case starts. First, it is the NCLT. What the decisions NCLT passed? The NCLT held that the transaction in question were to default the lenders of the corporate debtor, JP, as the unencumbered land owned by them to secure the debt of the related party, Joyprakash, was mortgaged in the midst of corporate debtors' immense financial crunch, continuing with default towards the home buyers and financial creditors, and after it had been declared as NPA. Even the financial position of the JP is very, very alarming. JP has mortgaged this corporate this land for the benefit of its parent company, Joyprakash, and that's why NCLT held that this is a preferential transaction. Further, the mortgage that the mortgage of land was created without any counter guarantee from the related party. That is Joyprakash. No counter guarantee received from Joyprakash. The tribunal was of the view that at the time when the mortgage was created, the corporate debtor was already in default, and it was unlikely that the lenders would have provided no objection for creation of such mortgage to secure the debt of a related party, as that would have compromised not only recovery of their dues, but also the interest of the thousands of home buyers. The corporate debtor means JP didn't take any counter guarantee from his parent company Joyprakash, nor it received any no objection certificate from its lenders. NCLT formed opinion when the directors of the corporate debtor were fully aware that they were in twilight zone. The insolvency was imminent. They ought to have exercised due diligence in minimizing the potential loss to the creditors. But they entered into such transactions which ex facie gave benefits to the related party Joyprakash with a clear intent to default to creditors of JP. The tribunal therefore held the transaction was a related party transaction with a look-back period of 2 years as per the provisions of the code. So this is the decision of NCLT. They said this is a related party transactions with look-back period of 2 years, and it attracts the avoidance transactions. Is it clear? Now, definitely the aggrieved party, that is JP, has referred this matter to NCLAT. So what NCLAT has mentioned, sorry, not NCLAT. This is referred to by banks, the creditors. So NCLAT observed that the corporate debtor had created interest over its property, but such interest had not been created in favor of any creditor or surety or guarantor for or on account of antecedent financial or operational debt or other liabilities owed by the corporate debtor, and hence section 43(2)(a) of the code was not attractive. Enclad is of the other opinion. He said this thing has been created for creditor or as guarantor for no antecedent financial or operational gain. So it will not cover under section 43(2)(a) of the code. We have seen already, na? The preference for financial transaction, there should be an antecedent debt owed by the corporate debtor. It was further observed that the mortgage in question were made in ordinary course of business. This happened, I mean, as per the Enclad, ruling out the applicability of section 43. Section 43 also said if it is ordinary course of business, then it will not be considered preferential transaction. Appellate tribunal said that the adjudicating authority had no power to pass order under section 44 of the code in the instant case. As regard applicability of section 66 of the code dealing with fraudulent trading or wrongful trading, the appellate tribunal observed that the corporate debtor, being one of the group companies like a guarantor, had executed mortgage deeds in favor of lender banks and financial institutions, and the transactions were in the ordinary course of business of the corporate debt. Enclad felt that since it is a group company, so this transaction is within the ordinary course of business. Thus, Enclad observed that in absence of any contrary evidence to show that they were made to defraud the creditors of the corporate debtor or for any fraudulent purposes, it was not open to the adjudicating authority, that is NCLT, to hold that the mortgage deed in question were made by way of a transaction within the meaning of fraudulent trading or wrongful trading under section 66 of the code. Enclad therefore allowed the appeal and set aside the impunged order passed by NCLT. So Enclad reversed the order of NCLT. I think it is clear to all of you. Now the matter was referred to Supreme Court. The Supreme Court in its judgment clarified certain key aspects. I request all of you, please very carefully listen to this. The Supreme Court in its judgment clarified certain key aspects in respect of preferential transactions under section 43 of the code. In fact, after the decision of the Supreme Court, necessary amendment has been made. I think it is first with effect from 1st June 2018 in the Insolvency Code towards section 43. The summary of its observations are as below. Under section 43 of the code, a transaction is said to be a preferential transaction if A, the transaction related to transfer of the property or interest of the corporate debtor for the benefit of a creditor, surety or guarantor in relation to an antecedent debt stroke past liability. And B, the transaction has the effect of giving such creditor, surety or guarantor a beneficial position in the distribution of assets in the event of liquidation under section 53 of the code. Further, for any such preferential transactions to be avoidable, it ought to have occurred A, in case of transactions with related party within a look-back period of 2 years, immediately preceding admission of the corporate debtor into insolvency, that's ICD, and B, in any other case within a look-back period of 1 year, immediately preceding admission of corporate debtor into insolvency. Transactions in ordinary course of business or financial affairs of the corporate debtor or the transferee which result in a new value for the corporate data are exempted even if such transfer fall within the aforesaid look-back period. So here Supreme Court said that transactions in the ordinary course of business or financial affairs of the corporator or the transferee, means the lender, which result in a new value for the corporate data, are exempted. So ordinary course of business we can say only when this transaction creates a new value of asset for the corporate data, number one. The Supreme Court issued a key clarification in respect of the exclusion of transactions conducted in the ordinary course of business from the ambit of preferential transactions liable to be set aside. Very important this is. The Apex Court held that for the exclusion of ambit as given in section 43(3) of the code, that the term or in the section must be read as an. You know, section 43(3) said that any transaction should be considered as a ordinary course of business if it is so for the corporate debtor, transferor, or the lender, that is transferring, or, but Supreme Court said this or should be construed as an. So we can say the transaction is in the ordinary course of business when it is for the benefit of both the parties. Both the parties have done these things in the ordinary course of business. For one, it is in the course of ordinary business. For other, there is some problem. Supreme Court said then it will not be considered as the ordinary course of business. For this, the Apex Court relied on the scheme and objective of the code and observed that the relevant consideration for the purpose of section 43 is the conduct and affairs of the corporate debtor, and to discharge such transactions which appear to minimize the potential loss to the other stakeholders in the affairs of the corporate debtors, particularly its creditors. So Supreme Court said that this transaction should not create any potential loss to the creditors of the corporate debtor. As such, even if a preferential transaction is undertaken in the ordinary course of business of the transferee company, that is lender, it would be included within the purview of a preferential transaction as long as it is not in the ordinary course of business of the corporate debtor. Who has asked me the question that whether these things, that 100 rupees has been given, asset has been given to settle a claim of 100 rupees, I request him to see these things very particularly. Even if a preferential transaction is undertaken in the ordinary course of business of the transferee company, that is the lender, it would be included within the purview of the preferential transaction as long as it is not in the ordinary course of business of the corporate debtor. And it will not be considered in the ordinary course of corporate debtor if it affects the interest of the minimize the potential loss, if it doesn't minimize the potential loss to the other stakeholders. Sir, have you received your, have you got your answer? Who asked me about the ordinary course of business? If not, please ask me again. In relation to the term ordinary course of business, the Supreme Court held that a transaction could be classified as such only if it was part of the undistinguished common flow of business done. and did not arise out of any special or particular situation. This is also another yardstick to determine whether the transaction is done under the ordinary course of business or not. This is as per the Supreme Court order. Accordingly, even though furnishing a security would be a normal business practice for a company, it would not amount to a transaction in the ordinary course of business. Maybe it is a very normal thing that the group company gives the security for his parent company. But in this particular case, since JP was in a twilight period, insufficient fund, they are already adjudged as NPA, it is not considered as an ordinary course of business. Supreme Court concluded that creation of mortgage by the JP had benefited Jaiprakash to avail loans from the consortia, and both of them are the related party. So look back period will be 2 years. Creation of such third-party security was not in the ordinary course of business of JP. By providing such mortgage, JP had deprived other creditors and reduced their recovery under Section 53, hence preferential transaction. The Supreme Court noted that the inquiry for the purpose of each of the avoidable transactions under the code is different, and that specific material facts would have to be pleaded to prove that a transaction falls under each of these such categories. I really request all of you, please, because I have again and again I'm saying I have only given the extract from the order. Please go through it. Is 100 odd pages, but what reading? Supreme Court noted that the inquiry for the purpose of each of the avoidable transactions under this code is different, and that specific material facts would have to be pleaded. What is true for one type of transaction may not be true for the other type of transaction. So if you say that it is preferential transaction, if you give the, if you give the evidences for the preferential transaction, you cannot say that it is an undervalued transaction, because according to this order, all have the different yardstick to determine the avoidance transactions. Step-by-step examination of each avoidance transaction on the basis of criteria specified in the provisions is required. Supreme Court mentioned about the duties of the and responsibilities of RP in CIRP as per Section 25 with respect to Section 43 in its order. The Supreme Court reversed and set aside the order passed by NCLAT and upheld the order of NCLT. All appeals preferred before NCLAT were also dismissed and found that Jaiprakash is not a financial creditor of JP. The Apex Court did not decide the issues related to undervalued or fraudulent. So, friends, this is the gist of the order given by Supreme Court. Also, I have discussed with you NCLT and NCLAT order in respect of JP Infotech. It is very, very important. And I believe that whatever doubt we have, that what is called as the differential transaction, ordinary course of business, everything is very well settled through this order. Okay. Now another very important thing is Venus Recruiters case. Venus Recruiters Public Limited Union of India. I think you are aware that initially the order was passed by the single bench of Delhi High Court, and the order of Delhi High Court really jeopardized the avoidance transactions filed after the completion of the CIRP process. There were many refusals from the different benches after this order came to accept the avoidance transactions applications where the resolution plans has already been approved, unless and until the division bench of Delhi High Court reversed that order and gave a new direction to this matter. So let's see that what is there. So Venus Recruiters Private Limited India Fact is that corporate insolvency resolution process (CIRP) was initiated against Bhushan Steel Limited by State Bank of India. The adjudicating authority admitted the application and appointed IRP, who later appointed as RP by the COC. On 20th March 2018, the COC approved the resolution plan submitted by Tata Steel. So 20th March 18, COC approval the Tata Steel plan. On 9th April 2018, sir, someone has the question now that when it will be filed, avoidance transaction, can it be filed after approval of plan? I request him that you please be very carefully listening to this question. On 9th April 2018, that is after the approval of resolution plan by COC, RP filed an avoidance transaction application under section 43, 45, 49 and 66 of the code on the basis of forensic audit report, because definitely the audit report came late. While approving the resolution plan on 15th May, then 20th March COC approval, 9th April filing of avoidance transactions, 15th May a resolution plan approved by the NCLT, but NCLT did not pass any order regarding the avoidance proceedings. On 24th July 2018, the NCLT issued notice on the matter regarding the avoidance transaction, and on 25th August 2018, implemented the petitioner of the instant case, Messrs. Venus Recruiters, a manpower contractor of the erstwhile Bhushan Steel Limited, as a party to the RP's avoidance application and issued fresh notice. Agreed by this, Venus Recruiters filed a writ petition before Delhi High Court, praying for proceedings against it in the NCLT to be quashed. So, Venus filed a writ petition before Delhi High Court. So, what are the issues? In the said writ petition, there are 3 issues for consideration. First was whether the former RP has the required locus to file an application for avoidance proceedings, because the resolution plan is already approved both by COC and NCLT. So still the former RP, because RP, there is no RP now as per the code. So whether the former RP has the required locus to file an application for avoidance proceedings. Second was issue of jurisdiction of NCLT to initiate and continue with the avoidance proceedings after the resolution plan, because if you see 65, section 60, categorically said related to insolvency or liquidation proceedings, the adjudicating authority is NCLT. Here the resolution proceeding is over because resolution plan is over. So after that, whether NCLT jurisdiction of the NCLT will continue. And this is the reason, for this reason they didn't go to NCLT, they filed a writ petition before Delhi High Court. Third was regarding the proceeds of avoidance transactions. Who would benefit from the adjudication of such application post approval of resolution? So these are the 3 questions with which the writ petition was filed. Now comes to the decisions of the single bench. The single bench of Delhi High Court, while allowing the writ petition, so they accept the writ petition, to quash the avoidance proceedings, ruled that the role of the RP is finite in nature and comes in an end after the approval of the resolution plan. So the single bench said, Delhi High Court said that no, RP is a role of RP is finite and it comes to an end after the resolution plan. So they have no locus to proceed with the avoidance transaction. Hence, he or she cannot act on behalf of the corporate debtor after approval of the resolution plan. The Honorable Court relied upon the Supreme Court's judgment in Committee of Creditors of SR Steel to analyze the role of RP and observe that the former RP does not possess the required locus standi to initiate avoidance proceedings. Further, the Honorable Court also emphasized on the strict timeline provided under the Code and its regulations and relied upon the Supreme Court's judgment in innovative industries to state that certainty and timelines is the hallmark of the IBC. Therefore, since the avoidance proceedings are time-barred, they cannot take place after the completion of CIRP. I already told you that this order jeopardize the avoidance transaction applications. As regards the jurisdiction of NCLT for continuing with avoidance proceedings after approval of resolution plan, the Honorable Single Bench Delhi High Court held that Section 60 of the Code, the adjudicating has the jurisdiction to deal with all applications and petitions in relation to insolvency resolution and liquidation for the corporate person. The insolvency resolution process has already come to an end with the approval of the resolution plan on 15th May 2018. And the NCLT exercise its jurisdiction post approval of the resolution plan. The jurisdiction of the NCLT is limited to insolvency resolution and liquidation. And after the approval of the resolution plan, the new management takes over. So you cannot say after the approval of resolution plan, since the new management comes into picture, that it is within the continuation of the insolvency resolution process or liquidation process. Further, regarding the proceeds of avoidance transactions, Honorable Court was of the opinion that found a careful perusal of Section 44 of the Code. The orders that can be passed by the NCLT are supposed to benefit the creditors and not the new management of the corporate debtor. Since after the approval of the resolution plan, the proceeds of the avoidance transactions cannot be inculcated in the resolution plan to be distributed amongst the creditors, the same cannot be permitted because resolution plan already approved and there is no provision that this amount will be distributed to the creditors. So the single bench say that no, it is not also permissible. So single bench further said the parties would have therefore left with their civil and other remedies and in terms of the contract between them. So they said that this type of things will not be covered under IBC. Maybe the parties can file the cases under the civil law or other remedies which they have as per their contract. So they dismiss the order of NCLT to make the Venus recruiter as a party to the avoidance transactions. And when you will appreciate this is very, very harsh, this decision of single bench, and really jeopardize the entire all applications filed after resolution plan for avoidance transactions. This benches say that okay, already Delhi High Court gave the order, they cannot proceed with these applications. But fortunately, the division bench on Delhi High Court on January 13, 2023 has finally decided the fate of avoidance or preferential undervalued applications filed under the Insolvency and Bankruptcy Code based on the case. Because Tata still gone to the division bench of Delhi High Court against that order of single bench. The division bench held that avoidance to preferential transactions can survive beyond the conclusion of corporate insolvency process and that the resolution professional will not be functus officio for pursuing the avoidance applications and can continue to pursue such application. Division bench is totally of the opposite view which expressed by the single bench. Honorable High Court has concluded that why they are of the opposite view, because they said the phrase arising out of, if you see section 65C, it is mentioned that arising out of or in relation to, as situated under section 65C of the IBC, is of a wide import. It is mentioned that any situation arising out of or in relation to insolvency resolution process or liquidation. So division bench said that these two words has a wide import, and it is only appropriate that such applications are heard and adjudicated by the adjudicating authority, that is NCLT or NCLAT as the case may be, notwithstanding that the CIRP has concluded and resolution application has stepped into the shoes of the promoter of the erstwhile corporate debtor. Is it clear, friends? They categorically said that because of these two phrases, everything, even if it is concluded, it is ideal should be handled by NCLT and NCLAT. CIRP and avoidance applications are by their very nature a separate set of what I have already told you, I mean, at the beginning of my presentation. CIRP and avoidance applications are by their very nature a separate set of proceedings wherein the former being objective in nature is time bound, whereas the latter requires a proper discovery of suspect transactions that are to be avoided by the adjudicating authority. The scheme of the IBC reinforces this difference. Accordingly, adjudication of an avoidance application is independent of the resolution of the corporate debtor and can survive CIRP. It can be filed after the CIRP is over. The endeavor of the IBC and its rules and regulations is to ensure that all the processes within the insolvency framework are time efficient. However, it cannot be accepted that avoidance applications will be rendered infructuous in situations wherein the resolution plan would not have accounted for the avoidance applications due to exigencies and that delayed initiation of action in respect of avoidable transactions beyond the submission of a resolution plan before the adjudication authority. This is because such an interpretation will render the provisions pertaining to suspect transactions of no result and let the beneficiary of such transactions walk away scot-free. Money borrowed from creditors is essentially public money, and the same cannot be appropriated by private parties by a suspect arrangements. If you have any question, please ask me. Otherwise, I'll just go on reading because this is very nicely interpreted. Why the application can be accepted? File to definitely yes. After the conclusion of CIRP. But again, friends, I have a word of caution for all of you that don't consider it always the IBC cases are decided on case-to-case basis. So, I mean, definitely all these wordings, all these expressions in this order will be used as a weapon in your case, but you have to have proper justification to get the favorable decision from the authority, adjudicating authority. Therefore, in cases such as the present one, wherein such transactions could not be accounted, the adjudicating authority will continue to hear the application. It follows that the RP will not be functious officio with respect to adjudication of avoidance applications in a situation as described herein above, there being a clear demarcation between the scope and nature of the CIRP and avoidance application within the scheme of the IBC, and RP can continue to pursue such applications. The method and manner of the RP's remuneration ought to be decided by the adjudicating authority itself. What I said that maybe you can pay for the cost of pursuing the application with the authority, adjudicating authority. because Venus recruiter division bench categorically said that it will be method and manner of the RP's remuneration ought to be decided by the adjudicating authority itself. This amount should be made available to the creditors who are primarily financial institutions and have taken a haircut in agreeing to accept a lesser amount than what was due and payable to them. Division said that okay, but this amount will go to the creditors who have taken the haircut. Honorable Division Bench has set aside the impugned argument of the single bench. The NCLT is directed to proceed ahead with the hearing of avoidance applications in accordance with section 44 to 51 of IBC. The amount which is recovered can be distributed among the secured creditors in accordance with law as determined by the NCLT. With these observations, the appeals were disposed of along with the pending applications. And I don't think there is any challenge in Supreme Court of this order. So here is the Venus recruiter's case. Once the single bench has really jeopardized these applications, but the division bench has reversed that order, and now it is very much clear that how it will be dealt with. This is also a very important, very interesting and important case. And this has the reference of Venus recruiter. 63 Moons Technologies versus Administrator of Dewan Housing Finance Corporation Limited. This order is passed by the NCLAT order. NCLAT allows the appeal against the order passed by NCLT Mumbai bench while approving the resolution plan of DHFL, in which it was stipulated that the recoveries from the avoidance transactions can be made available to the benefit of the resolution appeal. Here, what's happening? NCLT Mumbai said that okay, fine. What the recovery is made through the avoidance transfer will be given to the resolution applicant. The appeal raised the following questions: whether stipulation in DHFL's resolution plan that the recoveries from avoidance transaction will be made available to the resolution applicant amounted to illegality. If any such provisions is there in the resolution plan, whether that will be considered as illegal. Whether the approval of the resolution plan to give such benefit to the resolution applicant was within the domain of commercial wisdom of COC. Further, if it is illegal, could it be saved by any majority strength within the COC voting in favor of the resolution plan? Can COC set right this illegality by the strength of the majority while approving the resolution plan? And lastly, can the successful resolution applicant appropriate recoveries from avoidance transaction application filed under section 66 of the code? So what is the decision of NCLAT in this regard? It was noted that based on various judgments of Honorable Supreme Court, the adjudicating authority should not undertake a judicial review of COC's commercial wisdom. So COC's commercial wisdom is supreme. However, commercial wisdom has not been defined anywhere. Therefore, what can be treated under commercial wisdom can be inferred from the powers given to COC under the code. Whatever the power COC has as per the code, they can play their commercial wisdom only in respect of those powers. Thus, while the AA adjudicating authority cannot interfere on merits with the commercial decision taken by COC, the limited judicial review available is to see that the COC has taken into account the fact that CD needs to keep going as a going concern during the insolvency resolution process, that it needs to maximize the value of its assets, that the interest of all stakeholders, including OCs, have been taken care of. So all these things, in contrary to all these things, all these parameters, COC NCLAT says COC cannot play their commercial wisdom. Cannot say it is our commercial wisdom not to adhere to all these parameters or any of these parameters. If A finds that all these parameters have not been kept in view while approving a resolution plan, the AA may send the approved resolution plan back to COC to reconsider and resubmit. So, friend, if the proceedings out of the avoidance transaction is given to the resolution applicant through the approval of resolution plan, it is to the contrary or the interest of all the stakeholders. So in this case, we will see. In the instant case, it was argued by the respondent that the court does not, respondent means that administrator of their housing, does not impede the resolution applicant's right to avail the proceeds from the avoidance transaction application. Though it is not impeded, it cannot be presumed that the court authorizes the resolution applicant for the same. So the Diwan, the COC of that administrator of the DHFL said that there is no restriction, that nowhere in the code is said that the resolution applicant cannot appropriate the proceeding to hold the avoided transaction. But the NCLAT said that true, it is not impeded, but it cannot be presumed that they are authorized. It is also not mentioned in the code that they are authorized to appropriate the proceedings of the avoidance transactions. NCLAT held that argument advanced by the appellants, that is 63 Moon Technologies Limited Council, that the ratio of Venus recruiters case applies to the facts of this case is correct. What mentioned we have seen in Venus recruiter, it categorically said that the proceedings, recovery of proceedings will go to the financial creditors who had suffered the massive haircuts. So NCLAT here also agreed to that view. It was further held that the ratio laid down by the Honorable Delhi High Court is that of the Constitutional Court, directly answering the issues before the NCLT and was binding on AA and NCLAT. Therefore, NCLAT held that the term in resolution plan that permits the successful resolution applicant to appropriate recoveries, if any, from the avoidance transaction application filed under section 66 of the code ought to be set aside because it affects the interest of the creditors or the stakeholders with the going concern interest of all the stakeholders, which the COC has to maintain. They cannot say that it is our commercial wisdom. So there is another case, Aditya Kumar Tribunal versus Om Prakash Pandey. This is NCLAT principal bench. National Company Law Appellate Tribunal principal bench comprising of Justice Ashok Bhushan and Dr. Alok Srivastava, Ms. Shesha Marla. In the case of Aditya Kumar Tribunal versus Om Prakash Pandey held that time period prescribed. I think this is also one of the questions during the session. Time period prescribed under Regulation 35A of the IBBI CRP regulations is directory in nature and not mandatory. Resolution Professional of Mr. Sri Balaji Forest Products Private Limited filed the appeal under section 61 of IBC against the order dated 26/2/2021 of LCLT Kolkata, wherein LCLT rejected the application by RP under section 43-45, read with section 49 and 66 of IBC by holding that the same is hit by Regulation 35 of the CRP regulations. So I am not going to the relevant regulations. We have already seen it earlier. So what is the brief facts of this case? Corporate insolvency resolution process of Balaji Forest was initiated by NCLT Kolkata via its order dated 18/10/2019. The ex-directors of Balaji Forest were not extending any cooperation to the RP, and therefore an application under section 19(2). I think this is the similar, this case has similarity to the case what with one of you. Under section 19(2) was filed by the RP against suspended directors, and an order dated 9/12/2019 was passed in 19(2) applications by NCLT, wherein NCLT directed the suspended directors to cooperate with RP, but still numerous hindrances were created in CIRP by suspended directors. Thereafter, audited balance sheet of Balaji Forest was finalized, and accordingly, RP filed an application under section 43, 45, wherein section 49 and 66 of IBC, which was dismissed by NCLAT. Contentions of RP. It was contended by RP that Regulation 35A of CIRP regulations is directory in nature and not mandatory, and NCLT cannot dismiss the application filed by RP merely on the ground of non-compliance with the timeline mentioned under Regulation 35A of the CIRP regulations. And what is the contentions of the suspended directors? It was contended by the suspended directors that the resolution professional has failed to comply with the requirements of Regulation 35, that is timeline of the CIRP regulation, and therefore the application filed by the resolution professional was rightly rejected by NCLT. Decision analysis by NCLAT. After hearing parties, NCLAT along with other issues framed two specific issues which are as follows: whether an application by the resolution professional relating to a transaction covered under section 43, 45, 49 and 66 is mandatory to be filed within the period of 135th day of the insolvency commencement date, and in event the application is filed beyond such period, the same is liable to be rejected due to non-compliance of Regulation 35A of CIRP Regulation 2016. Question mark, whether it is so. Whether time period prescribed under Regulation 35A of CIRP Regulation 2016 is mandatory or directive. NCLAT observed that expression used in Regulation 35A, shall form an opinion, shall make a determination, and he shall apply to the adjudicating authority, and it has to be ascertained what is the intent and purpose of using the expression shall in Regulation 35A. So NCLAT has interpreted why the word shall has been inserted in this regulation. NCLAT held that Regulation 35A of CIRP regulation imposes a duty on the resolution professional to take measures within the timelines as prescribed. In performance of such duty, the public in general has no control, including the corporate debtor. In event it is held that if any action taken by resolution professional beyond the time prescribed in Regulation 35A of the CIP regulations is prohibited, it shall cause serious general inconvenience or injustice to the corporate debtor. One of the objectives of the code is to maximize the assets of the corporate debtor. Hello, I think someone of you has asked this question, no? Hello? Hello? Hello, I am audible. Hello?
Yes, sir, it is important, sir.
I think some of you have asked this question, no?
Yes, sir.
So you get the answer.
Yeah, maybe continue, sir.
In the event
Yes, sir, it's very relevant.
In event the actions taken by the resolution professional after the timeline prescribed in Regulation 35A of the CIP regulations are to be annulled, the undervalued and fraudulent transaction will go out of the reach of resolution process. Same thing was given in the Venus Recruiter's decision also by the division bench. Reach of resolution process, reach of the court and shall cause general inconvenience and injustice to corporate debtor. Hence, we are of the view that timelines prescribed in Regulation 35A of the CIP regulations is only directory, and any action taken by the resolution professional beyond the time prescribed under Regulation 35A of CIP regulations cannot be held to be non-est or void only on the ground that it is beyond the period prescribed under Regulation 35A of CIRP regulations. When again and again I am saying you have to find the justification for the delay. There is a provision, there is an order, this order, which is in your favor, but you have to substantiate it. It is not that since it is mentioned here, you can also take free of this. No. There may be genuine and valid reasons for the resolution professional not to file application the series for avoiding the transactions within the time prescribed, which are questioned relating to each case and has to be examined on case-to-case basis. And if there are reasons due to which resolution professional could not file the application within the time, the same has to be examined on merit. So this is the order of NCLAT here. We are already, I mean, do you continue or? Hello?
Yes, sir.
I have two more cases. Should we continue?
Yes, sir. Yes, sir. Sure.
Okay. The next case is Amit Dinesh Chandra Patel versus Chandra Prakash Jain, RP of Syntex Prefab and Infra Limited. Friends, I have collected some case laws which related to this evidence transaction, but there are many others also. So I request you please go through all the case laws, I mean, where it is mentioned for to take the proof in your favor. Okay. Like this case, you see that the application was filed by the suspended director of the CD. What he is mentioned that COC in their meeting decided to undertake the transaction audit of CD with effect from 1/4/2018 to 1/2/2021. A firm of chartered accountant was appointed to conduct the said transaction audit. Subsequently, the COC decided to conduct forensic audit by the same audit firm, and they were informed about the period with effect from 1/4/2015 to 2/3/2021. The RP informed the auditor that the audit for the period done will not form part of the transaction audit, and that earlier period, but will be considered as forensic audit. The contention of the petitioner, that is the suspended director, was that Section 43 and Section 50, which deals with preferential and extortionate transactions, respectively, specified the look-back period as 2 years preceding insolvency commencement date. Maybe it is for the related party. And therefore, the audit of 6 years, because they asked the forensic auditor to audit for 6 years, 15 to 21, is beyond the purview of the court. The petitioner cited the case of Honorable Supreme Court Amit Jain versus Axis Bank in this respect. So they said that they filed the appeal, they filed the application before NCLT, Ahmedabad bench, that this is not permissible under IBC. In his reply, RP stated that it was brought to the notice of COC that CD had demerged from the parent company Syntex Industries Limited with effect from 1/4/2015 through a scheme of arrangement as approved by NCLT, and that on physical verification, very few assets were physically found though the properties and plant and machinery were shown at very high value. He further stated that COC had approved the forensic audit and the cost of such audit shall be borne by the COC and shall not form part of the CIP cost. So it is a standalone basis. COC is interested to conduct this 6 years forensic audit. Again, he mentioned that the look-back period is applicable only to the transactions covered under Section 43 and 45, and there is no such restrictions for transactions covered under Section 66 of the Code. We have seen it. After considering the submissions made by the parties, the Honorable NCLT held as follows. Once the CIRP sets in, the management of the company passes in the hands of IRP/RP and COC. The suspended management has no role to play. The time limits of NCLT of the opinion that the suspended director cannot file this application.
Hello.
Hello.
Namaste.
Hello.
Yeah,
can you please mute yourself, please? We are end of our discussion, so kindly.
Yeah, tell me, sir. We have replied your answers yesterday.
We received reply. In a meanwhile, will there be any more extensions, sir?
Hello, can you please mute yourself?
No. You only want extension or what? Then you.
Hello, Prasanna ji, can you mute yourself?
You are asking
Hello,
whether
Prasanna
there will
ji.
be any further extension. How long we can go?
Who is from ICSI? Can you please, Administrator, can you please mute him? The time limits of look-back period given in section 43 and 50 are to be considered by the adjudicating authority while considering the application, if any filed under these said sections. The Honorable NCLT noted that cost of the forensic audit will not form a part of the CIP cost and will be borne by the COC. Therefore, the adjudicating authority felt that it will not be proper to restrict the COC from carrying out the forensic audit independently relating to any point. If COC wish, if COC bears the cost, it can conduct the COC forensic audit for any period. The adjudicating authority held that the judgment of SC, as mentioned by the petitioner, that is origin case, does not put any restrictions regarding the time limit or look-back period for initiation, conduct of transaction audit or forensic audit. Maybe look-back period for 2 years, but there is no restriction. I can conduct it. When I file the application, it is the adjudicator will only see whether I have complied with the thing. You get me? So at this stage, it cannot be stopped. The locus standi of suspended management to interfere and prevent audit is questionable, as the suspended management has no role after initiation of CIRP. Further, rights of the applicant suspended director are in no way prejudiced by initiation of audit. The Honorable NCLT felt their intervention on the matter at this stage is unwarranted and dismissed the application. If you have any question, please ask. And I think the last case is that Amardeep Singh Bhatia versus Abhishek Nagori, liquidator. Grounds of the appeal is the learned counsel for the appellant submitted that a bare reading of section 43 and 46 of the code show that the relevant time, again it is for the time, look back period, sorry. Show that the relevant time is either 2 years for a related party and 1 year for any party other than a related party prior to ICD. Even fraudulent transactions prior to 2 years of ICD cannot be investigated by the liquidator, and therefore the adjudicating authority has erred in permitting the investigation of transactions beyond 2 years. As the liquidator cannot investigate a corporate debtor beyond 2 years from the ICD, the personnel of the corporate debtor under section 19 of the code cannot be expected to cooperate to provide documents for a period beyond this time period. The decision from Appellate Tribunal, NCLAT held that in section 43, 45 and 46 of IBC, though the relevant time is provided for under the code, the fact remains that unless the liquidator scrutinizes and peruses the material which is relevant, this is very important point. Unless the liquidator scrutinizes, unless RP also scrutinizes and peruses the material which is relevant to determine whether the preferential transactions or undervalued transactions took place at the relevant time, he cannot come to a conclusion as to whether these transactions took place during the relevant time. So you have to give me the document. Somebody has asked that they are not giving the document. They have to give you the document to ascertain the real position of this transaction. The appellate tribunal agreed with the contention of the liquidator that unless he is in the possession of all the material documents, he cannot determine whether they are undervalued transactions or preferential transactions during the relevant period of time, and therefore the corporate debtor cannot deny these documents at the threshold itself. NCLAT observed that for the fraudulent trading or wrongful trading as provided for under section 66 of the code, there is no look back period specified. So unless and until I know that whether it is preferential, undervalued, you cannot stop me. You can say that there is a look back period. When I will file my application, if I go beyond that look back period, you can put your objection there, then only. But unless and until it's meaningless. If the liquidator finds that there is a fraud committed by the corporate debtor at any time, he can approach the adjudicating authority and file the application seeking the necessary action. There is no look back period for fraud. There is no provision in the code for appellant to invoke the clause concerning relevant period of appellant means that I think the corporate debtor. Amardeep Singh Bhatia. Yeah, he is corporate debtor. There is no provision in the code for the appellant to invoke the clause concerning relevant period of 2 years solely on the ground of denying documents and information directed to be given to the liquidator. NCLAT said the adjudicating authority has rightly invoked its inherent power under Rule 11 of the Company Law Rules 2016 in the interest of justice to direct the promoters to provide the relevant information. It was observed that Section 213 of Companies Act 2013 empowers the tribunal on an application made to it by any other person or otherwise, and if it is specified that there are circumstances suggesting that the business of the company was conducted with an intent to defraud its creditors, the tribunal can pass an order after giving a reasonable opportunity of being heard that the affairs of the company ought to be investigated by an inspector or inspectors appointed by the central government, and where such an order is passed, the central government shall appoint one or more competent person as inspector to investigate into the affairs of the company. On an application preferred by the liquidator seeking clarification, because this is happening, this is made, this though its provision is under Companies Act, NCLAT feel that this is also applicable for the liquidation process. On an application prepared by the liquidator seeking clarification as to whether the liquidator was allowed to investigate the transactions executed or entered into by the corporate debtor beyond 2 years from the ICD and relevant records can be asked for from the promoter, the adjudicating authority has affirmed that the promoter should give the necessary documents to the liquidator and cooperate to enable the forensic auditors to complete the audit. NCLAT held that having regard to the fact that Section 66 of the code does not contemplate any look-back period, and also having regard to the fact that unless the liquidator scrutinizes the document, he would not be able to finalize and conclude whether the transaction falls under Section 43 or 46 of the code. NCLAT was therefore of the considered view that there is no illegality or infirmity in the order of adjudicating authority having exercised its inherent power under Rule 11 of NCLT Rule 2016, and hence the appeal failed and was accordingly dismissed. So I am through with my presentation. If you have any question, you can ask me. So any question you have?
So fantastic presentation, sir. Congratulations. You have taken the post-lunch session very well.
Thank you so much.
Thank you. Thank you for all your efforts. We request
I
you
will
to share
be happy if it is really helpful to you.
Yes, sir. We would request you to share the PPT presentation so that
Sure.
you could inform the ICSI people so that they could share with all the participants. Thank you, sir.
I'll do that. I'll do that. So anything else?
Thank you, sir. Thank you very much.
Thank you. So anybody from ICSI here?
Thank you so much, sir. The session was very nice.
Thank you so much. So can you conclude the session? Hello?
Yes, sir.
Can you conclude the session?
Yes, sir.
I thanks all the party. Really, I personally have really very much enjoyed this session because it was so interactive, and I will be very happy if it is really helpful to all the participants. So thank you so much. Thanks.
Thank you, sir. Session was very informative and nice.
Thank you, Zee. Thank you.
Thank you. Thank you.
Please share the PPT.
Sure, I'll do that. I will send it to the ICSI. I think they will send it.
Thank you, sir. Thank you.
Thank you.